Hello everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado. You're watching All Up in Your Business, where today we're going through your comments, responding to them, and answering some of your legal questions. Before we get into all that though, keep in mind that I am a lawyer, but I am not your lawyer. So the stuff that I talk about in this video is not a substitute for actual legal advice. If you need help with any legal situation, you should consult with a lawyer. All right. Enough of that, let's get into your questions. Oh, Bird, it's the mailman. The mail person is here. Bird may or may not hang out by the window. She's pretty scared of everything. Okay, can your registered agent address be in another state? No. The registered agent address for your LLC or your corporation, your entity, the registered agent address has to be in the state in which your entity is formed. So no, has to be in the same state. Physical location, same state. I am from India. Can I file a trademark by myself without an attorney? Unfortunately, no. If you don't have a domicile, a physical presence in the United States, then you do have to be represented by a U.S. licensed attorney to get a U.S. trademark. In that process, it's required that you have a U.S. licensed attorney representing you through it. Back to the registered agent questions. Wait, so what am I supposed to do for a registered agent address if I can't use my virtual business address for that? That's half the reason I even got the virtual business address in the first place. I hear this coming up a lot. I'll answer your question first. Use a registered agent service. Get a registered agent service, use their address. I see this coming up a lot. People confusing, mixing up, not knowing the difference between a business address, a virtual business address service, and a registered agent service. They serve two completely different purposes. Sometimes, and pretty often, the same vendor, the same service provider provides both, and you can have a virtual business address, which is also the same as the address that you can use for your registered agent. But strictly speaking, at their core, a virtual business address is to be used as your business's address, whereas the registered agent service, that address is to be used as your registered agent. Ne'er shall the two meet unless that's part of the service that you purchased and you're paid for, or the service provider is okay with it. So use a registered agent service for the registered agent address and a virtual business address service provider for the virtual business address. In the development timeline, when could or should someone switch from just a side hustle to an LLC? When could someone do it? At any time. There's no rules on when you can or can't, or when you have to go from a side hustle just operating as like a sole proprietor to now forming and operating as an LLC. No rules. When should you? That's really a personal decision. I would say once it's no longer just a side hustle, once you start committing like full-time time to this project, where it's either close to your full-time job or it is your full-time job, or if you're starting to generate full-time type of money, then it might be appropriate to make that switch to an LLC. But in the end, really, like I said, it's a personal decision. How much risk tolerance do you have? What kind of industry are you in? How much exposure to liability and getting sued do you have? Some industries, the chances of you getting sued are very, very small. So even if you're making a lot of money, why bother with the LLC? Versus some industries where there's a real good chance you're gonna get sued by somebody. So even if this is a tiny side hustle and you're not making any money, that LLC is gonna benefit you. Best thing I can tell you, go with your gut and or talk to a lawyer who's licensed in your state. They can help you hopefully decide what's the best route to take. Here's the million-dollar question. Are you still subject to taxes not only on what the business made in profits in a year, but also if you take, let's say, 30% of it into your personal bank account? Yes, you're still subject to taxes. But it doesn't matter, assuming you are operating, let's say, as a sole proprietor or an LLC, taxed as a sole proprietor, that's considered a disregarded entity, a pass-through entity. The IRS treats single-member LLCs and multi-member LLCs as if the LLC doesn't exist when it comes to profit and tax. All of the taxable income to the business is treated as taxable income to the LLC owners, regardless of how much or how little they actually take for themselves into a personal bank account. So yeah, still subject to taxes on all of the business, not all of the profits necessarily, because we have the revenue and, you know, expenses, but whatever the ultimate, you know, taxable income is for the business, that's all subject to taxes regardless of how much or how little you've taken into your personal account. A skincare company in Korea has a name word marked trademark that's live and registered, and I would like to use it for my company. Their company name isn't the same as the word mark name, nor do they have social media or domains as the registered word mark. Is it safe to use this name as my company name? There's a lot going on in here. When I'm taking this to mean, a skincare company that's based in Korea has a live and registered trademark for a word mark. It's not the same as their company name. They don't have social media or domain names in that registered mark. That part doesn't matter. They have a live registered trademark for this word. It doesn't matter if that matches their company name. It doesn't matter if they don't have that same domain name or social media. Totally irrelevant. Is it safe to use this as my company name? I'm gonna take the safe answer and say no. That's the safe answer. If you want to name your company the same as something that is a registered trademark, probably not. I'm assuming you're doing something in the skincare, makeup, cosmetics industry. If you're not doing anything even remotely related to that, then that's probably okay. The reason I say this is the safe answer is just like it doesn't matter that their company name is the same, it doesn't matter really what your company name is. If you're not using that company name as a trademark, then this Korean company shouldn't have any reason to, you know, go after you. Just because your company name is one thing, that doesn't mean your trademarks are that same thing. So frankly, I need a lot of more information. You should consult with a lawyer, a trademark lawyer, about this. I'm happy to help with you further, but what you've given me here isn't enough to really give you a good, solid answer. But to play it safe, I'd say no, don't use that name. Great video, very informative, thank you. Since trademarks are associated with a product or service, what would happen if a company does something outside of its trademark product or service? Nothing. Nothing really happens. Whatever your trademark is registered with, the goods and services, that doesn't mean you're now bound to only offer those goods and services. That's just what your trademark's registered for. You're still free to offer whatever goods and services you want to, regardless of what's on your trademark registration. All that really means is that your trademark registration isn't going to necessarily apply to those other products and services now. So that's all that means. Doesn't really make a difference. But if you do branch out and start offering more products and services than what you've got in your existing trademark, it's usually going to be a good idea to go back, reapply to get the trademark registered for those new products or services. How does the member of the LLC access the profits from the LLC? For a small landscaping business, would you, I know you can't recommend blanket statements, but in general, how does the member of the LLC access the profits? They pay themselves from it. Usually we call this a member distribution. You can physically, how do you do it? You can transfer money from the business account into your personal account. You can write a check from the business account into your personal account. The method by which you do it doesn't really matter. You take the profits, you take a withdrawal, a distribution of the profits, and that's how you as the member pay yourself. Looking for advice on trademarking a design I'm selling on shirts. What's the cheapest way to do this? Any advice is greatly appreciated. The cheapest way to do a trademark is to complete the application yourself and not pay anybody else to do it. That will get you, depending on the specifics, the very minimum that's going to cost you is $350 for the USPTO application filing fee. There's a potential that there could be additional fees associated, but at a bare minimum, it's going to be $350 for that initial filing fee. If you do it yourself, everything goes smoothly, there are no other fees that come up, then that's all you'll pay. So that's gonna be the cheapest way to do it. Is that the best way to do it? No. good chance you're going to screw it up, and then you'll end up having to pay somebody else to fix it anyway. The cheapest way, in my opinion, is to sign up for my Brandish DIY Your Trademark online course, where I teach you step by step how to go through the application process by yourself. It's going to be cheaper than working with an attorney directly. It's going to be better and probably cheaper than using one of those non-attorney filing services. That's going to be a waste of money. So it's going to be cheaper and better than that option. But it's going to be slightly better than just winging it, freeballing it on your own and trying to figure it out by yourself. Do you only work out of Colorado? I'm in Texas and would love to use you for my single member LLC. Generally speaking, yeah, I only work out of Colorado, particularly with forming LLCs. I can only help folks with that if they are in Colorado, if they're forming the LLC in Colorado. The exceptions to this rule primarily is trademark registration. Federal trademarks are governed by federal law, so I can work with anybody, anywhere when it comes to federal trademark registrations. Same with copyright registrations, again, federal law, so I'm not bound by state rules. But with pretty much everything else, especially LLC formation, really just Colorado. All right, last question here. Hi, I have a question. I registered my brand name today. Congratulations. Does the registration also cover variations in capitalization? For example, with or without uppercase letters? Hello, hello, hello. Assuming you registered for the brand name as a standard character mark, so just the words, no design element to it, it's not a logo. Yes, the registration covers all variations of capitalization. Doesn't matter what's capitalized, what's not. A standard character mark covers the standard characters regardless of how they look, regardless of capitalization, all of that. So yep, assuming you did that. If it's a design mark, then no. No. But if it's a word mark, then yep, you're good. All right, folks, that's all for this round. If you learned a thing or two, give me a thumbs up, please. I talked a little bit about Brandish, my trademark course. If you want to learn more about that, you can check a link for it in the description. I'll have additional information and resources down there as well. Keep the good questions coming. I have a lot of fun making these videos, going through your questions and answering all of them, so keep them coming. Thank you so much for watching. I'm Aiden Durham, and I'll see you next time.